Judgment in the appeal, Tael 1 Partners Limited and Morgan Stanley and Company.
Lord Reid will explain the decision of the court.
This appeal is concerned with the interpretation of one of the conditions in a standard form of contract used in the financial markets. The contract is the standard terms of the Loan Market Association, the LMA. It is used when commercial loans are traded. The lender may sell his interest in the repayment of a loan to a third party, who may in turn sell it on to someone else, and so on. Such sales commonly take place on the LMA standard terms. When the lender sells his interest, he is, of course, selling the right to be paid the principal and interest due under the loan by the borrower. In commercial loans, there is also commonly a provision for the borrower to pay a lump sum called a payment premium when the principal is repaid. Under the loan with which this case is concerned, the amount of the payment premium depends on the circumstances in which the principal is repaid. For example, whether it's repaid on the date specified in the agreement or on an earlier date because the lender has exercised a right to demand early repayment, or on an earlier date because the borrower has chosen to repay the principal early. The premium is calculated as an amount which is equivalent to interest over the period until it is paid at an interest rate which depends on the circumstances. Other amounts may also be payable at the same time as the premium, depending on the circumstances, and they are taken into account in calculating the amount of the premium. The result of all this is that it is impossible to predict in advance either the amount of the premium or when it will be payable. When the loan is traded, there is likely to be interest which has accrued but has not yet been paid. And that's the position in the present case, where the loan agreement provided for interest to be paid 3 monthly in arrears. The LMA standard terms provide various options to deal with that situation. For example, the loan may be traded on the basis that the buyer will pay the seller the amount of the interest which has accrued but not yet been paid. And that is what was agreed in this case. The question in the appeal is whether the LMA terms also require the buyer to account to the seller for part of the payment premium once it is paid. The appellant, Tael, argues that they do. The premium, they say, is effectively equivalent to interest, and part of it is therefore attributable to the period prior to the date when the loan was sold. They argue that it's covered by a condition in the LMA terms which requires the buyer to account to the seller for any interest or fees which are expressed to accrue by reference to the lapse of time. In the commercial court, the judge accepted that that condition required the buyer of the loan, Morgan Stanley, to pay Tael a proportion of the payment premium. The Court of Appeal disagreed and allowed Morgan Stanley's appeal. Tael now appeal to the Supreme Court. The Supreme Court unanimously dismisses the appeal. It is true that time enters into the calculation of the payment premium, but the premium is not, as the condition requires, expressed to accrue by reference to the lapse of time. The premium accrues, not by reference to the lapse of time, but on a defined event, namely the repayment of the principal amount borrowed. That conclusion is reinforced by the commercial context. The LMA terms are intended for use in a market in which loans are traded possibly many times between many different parties. It's unlikely that a contract in a market of that nature would be intended to create rights and obligations continuing possibly over a period of years. Furthermore, the LMA terms do not provide any means enabling the seller to know when the payment premium has become payable or in what amount. And some such provision could have been expected if the seller was entitled to part of the premium. These practical considerations support the natural reading of the LMA terms themselves.